Can we start?
Boleh, Cik Zakri.
Okay. Bismillahirrahmanirrahim. Assalamun alaikum and good morning to everybody. I'm Zakri, the General Manager of Strategic Services, and on behalf of the Malaysian Employees Federation, I'm delighted to welcome all of you to the MEF Online Membership Drive. The purpose of this webinar is to encourage more companies to join the Federation as members. And during this 2-hour session, we will be featuring our in-house experts. We'll be sharing valuable information pertaining to the roles and function of the Federation and also on the current employment situation in Malaysia. And we will kick off with a presentation on why you should join MEF as a member. And to further convince you, we have invited Puan Hajah Haslina Ismail, the Senior Manager of Membership and Communications, to speak on the topic. And following that, Dato Jalaldin, our highly experienced Senior Industrial Relations Consultant, will be sharing his insights on discrimination in the workplace. And at the end of our session, we will have a brief Q&A session where you can submit your questions through the pigeonhole. I think the link is in the chat box. So ladies and gentlemen, without further ado, it is my pleasure to invite Puan Hajah Haslina to brief you on the benefits of becoming a member of MEF and the process of joining. Silakan Hajah Haslina. Hajah, your mic is off.
Okay, sorry. Bismillahirrahmanirrahim. Assalamualaikum and a very good morning for those of you who are online this morning. And my role, as being mentioned by Encik Zakri, is none other than introducing you to MEF, the roles and functions as well as services that we do. So later on, I will pass the floor over to Dato Jalaldin, who will be speaking on the very important topic, which I believe that is the attraction of today's webinar. So without further ado, let me just share with you my slide, yeah? All right. Okay, so the overview of MEF. Perhaps most of you have heard of us before, yeah, but you do not really know what we do. Okay, so for this coming half an hour, I will just explain to you on all the things that have been coming into your mind. What is MEF? You have seen we came out in the press, yeah, be it the printed paper, be it the electronic media. So MEF express the views of employers, where in Malaysia, if even the government or the NGOs or even the media, they want to know about MEF or the employers' views, MEF will be the contact point for the opinions of employers in the country. Okay, we also express business needs of employers. I stress the word business needs is because MEF does not only apply or maybe involve in the human resource aspects only, yeah, but we do care and put our interest in every, or we call it the entire spectrum of business needs of employees in the country, particularly the private sector employers. And we also represent Malaysian employers, be it in the national arena, be it in the regional, as well as in the international level. And as you can see on the slide which I'm sharing right now, we regularly appear in the talk shows, yeah, in the broadcast media and so on. Okay, now, so in a nutshell, we say that MEF is the place where employers or business owners or HR personnel coming here to seek professional assistance in your daily work when you deal with employees. Okay, right. So what is MEF actually? From the word employers. So we are actually Malaysian Employees Federation, or in bahasa it is Persekutuan Majikan Malaysia, and we are the central organisation of private sector employers in Malaysia. Now, so since our establishment way back in 1959, so this year we are coming to be 64 years old, yeah? We have 6 other regional offices nationwide, where our headquarters is located in Petaling Jaya. Okay, now, when we claim ourselves to be the spokesperson or represent the employers at the national level, as you can see on the slide which I'm screening now, all those the councils that being featured in the slide, they are tripartite in nature, where for the employers' views, MEF will have a representative, say for example in the NLAC, in the Wages Consultative Council. We also have our representative in EPF board, MPC board, NIOSH board, and so on and so forth. Yeah, HRDC board, then SOCSO board, yeah, TVET board dan sebagainya. Now, so that is at the national level. While at the regional level, we are a founder member of ACE, which stands for ASEAN Confederation of Employers, and establishment which was created in 1978. And there are 7 members within the ASEAN region which are members of ACE. And we are also a founder member of CAPE, that is the EOs, or the employer organizations in the Asia Pacific region, where MEF is also a member of CAPE, comprising of 20 members or 20 EOs in the 20 over countries within Asia Pacific. Yeah. Now, we are also a member of IOE, International Organization of Employers. That establishment of IOE is actually representing 140 over countries around the world. And we are also a member of IOE. And every year we take part in the International Labour Conference, where this is the highest body or a platform discussing labor issues at the world level. Yeah. And ILC is actually being established way back in 1919. And it has 187 member states, which every year they meet up in the ILC conference. Yeah. Now, so for the last 64 years of our establishment, MEF participates actively in the various government dialogues. Yeah, like initially when I mentioned that we are not only dealing with human resource aspects of companies, yeah, because say for example on in terms of business interests, yeah, like for workers, like economic, like the future of the graduates and so on. Yeah, so we give our views of based on the collection, the collective data that we got from our members throughout the country, and we put up representation on these various matters to the various ministries, to the numerous ministries. Say, for example, not only the MOHR, we also actively participate with the Minister of Finance dialogue, with MITI dialogue, yeah, with entrepreneurs dialogue and so on. Okay, now, so for MEF, what is an association without members? Jadi, okay, MEF is being established under the Register of Societies Act, yeah, ROS. And then we have members. Our members are actually located nationwide, yeah. As long as they are privately run, okay, the establishment can join us as members. Jadi, these are the type of services that we provide to our membership. Okay, number 1 is industrial relations. In short, we say it's IR, right? Industrial relations. And then we also have big data, research and information. We also have IT services. We also have OSH services as well as training. Okay, now, before I proceed further, let me just explain to you. Okay, say for example, you are an HR of a company outside there. Okay, now you will be asking, if I were to become a member, what do I get? Okay, and normally we will explain this very clearly in the beginning, where we do not want in the end you will say that, hey, I thought we are member, everything is provided free. No, that's not the case. Let me just explain to you, because our services are being divided into two categories. Yeah, number one is free-based services. Free-based services are the ones that include advice and guidance. Of course, you can always pick up your phone and ask our consultant for any clarification you would like to have on employment issues. Yeah, you can email to us your questions, or you can fax, or you can access through our members portal. This is where our IT services just now came in. Okay, and the best thing is, if you would like to sit down with our consultants, you can make prior appointments to see them. It is all FOC, free, because you're our member. Okay, now you will also be getting regular email blastings. Yeah, okay. Our emails consist of circulars, announcements, like government just announced on something which is related to labor issues. We will regularly email blast to you. Okay, now, number three is, let's say, okay, I stress the word, that's simple written opinion. Okay, say for example, you become a member for the first year. I believe not every day that you face problems or you like to ask us questions. Say, for example, during the first year of your membership with us, you can make it worthwhile. Say, for example, you want us to review, katakan, your letter of appointment, for example. So you approach our consultant, you would like to get our opinion on the letters that you have been issuing for years. Yeah, maybe surat tu, it was drafted by your previous HR for the last 10 years. You are using the same letter, contoh. Jadi you can get our opinion on the written opinion on simple documents such as that lah. Okay, now, and then lagi satu, which is a very, very important service that we provide for you as business owners or HR practitioners. You are invited to attend our monthly meetings. Okay, our monthly meetings are held online. Ya, jadi tak ada masalah, tak ada issue of you nak pergi, you leave your company ke for a while, tidak. Tapi our monthly meetings are scheduled way ahead. Say for example, contohnya your company is located in Klang Valley. Katakanlah your alamat, your address is in KL. Jadi you are under the Central Group Region. Okay, the Central Group Region meeting is held every third Wednesday of the month. Jadi you know already the schedule. Okay, so what you can do is that normally we will email to you. Remember the regular email blasting too, which also include the notice of meetings. Okay, now, jadi since it is online, maybe 4-5 orang from your HR department who would like to attend our online meetings, dipersilakan. Because during our monthly meetings, there is an avenue for you to update your knowledge on HR. Or even macam contohnya katakan, like our consultants, like macam contohnya Dato Jalaldin, who is a speaker today, dia pun akan address some topical issues in the interest of employers during our monthly meetings. Normally tu, kalau say for example, if the meeting starts at 2, maybe for the first half an hour ataupun 1 hour, we will have 1 or 2 speakers to address you on topical issues which are of interest to the employers, and then followed by the normal agenda of meeting lah, like current disputes, discussions dan sebagainya. Jadi, this is part of the free-based services that as a member, you shouldn't miss this opportunity to update your knowledge on HR dan juga the latest employment matters in the country. Yeah, during our monthly meetings. Kalau let's say if you were to miss the meetings, jangan risau, you will always have the access to our minutes of meetings. Yeah. Now, Another service which I mentioned tadi tu is the IT services tu. It is access to MEF members portal. Okay, we understand that as a company, probably katakan you punya HR is a lady kata who goes on maternity leave ke whatsoever. Jadi, how about other people within your HR team? They would also like to have access. Jadi, every company, we will have 4 persons within your organization to be given the user ID password to have access to MEF members portal. Menarik kan? Alright, now. And then last but not least is, of course, since the last 2 years, we have been bogged down, at home for the MCO dan sebagainya. So we created the WhatsApp group. Jadi each company lah kita bagi satu orang to have the access to our members WhatsApp group. Jadi lah WhatsApp group ni, at any time people can post questions, it will be answered, and other people can also share, their views on those particular questions. Okay, now let's look at the fee base pula. Fee base ni is, for example, court representation. Court representation is something like your company, katakanlah you accidentally lah, last time you dismiss ke, you terminated a staff kan. Jadi staff tu tak puas hati, pergi report to Labour Office dan sebagainya. So you will be summoned to appear untuk jawab, the claim made by your ex-staff contohnya. Jadi, there's no need for you to go helter-skelter, cari a good lawyer to represent you, because MEF is there. We have a pool of lawyers who are very highly experienced and knowledgeable on labour matters. Jadi, it will be a fee-based services because MEF will represent you, and it will be chargeable lah. Tapi our charges are very minimal, I assure you. Because kalau kata you go to a lawyer, a legal firm, they will charge you exorbitantly. Okay, jadi kita punya we charge minimally sebab you are our member. And then this is a special service that we provide only to members. Kalau you are non-member, we cannot represent you in court cases. Okay, now, and then we move on to the second bullet there, which is consultancy packages. Consultancy packages is something which is, let's say your company needs the service of reviewing of a handbook review, ataupun you would like to start from scratch. We can do that. That falls under consultancy package. Okay, jadi consultancy package ni in which we will give you a quotation first. Okay, depending on the complexity of the document, the complexity of the job. Jadi kalau it's agreeable, then we proceed. That's why we call it the packages lah. Jadi even kalau macam you would like us to do the HR audit pun boleh, OSH audit pun boleh contohnya. Jadi bear in mind that fee-based services for court representation and consultancy packages are solely for MEF members sahaja. Okay, non-members we can offer you those services. Now, the 3 other bullets, seminars, webinars, conferences, trainings, as well as publications, these services are open to members and non-members. Tapi, of course, members will be getting discounts, for the books, the trainings, and then the seminars that we conduct, which I will move on later on and explain to you. Okay, right. I hope it's clear here now. Okay, now, just for the IR tadi, to recap what I just mentioned tadi. So, for you to be our member, you will be getting the advisory, opinion, advice via phone, fax, email, face-to-face. And then kita ada interaction group through WhatsApp. Kita ada court representation for labour court and industrial court saja. Kalau high court semua kita tak boleh pergilah. But we can katakan you to a lawyer yang boleh sambung the case that we do for you first. And then we are also doing conciliation cases at IR department. Just bear in mind, any other lawyers tak boleh represent companies except MEF. dia ada dalam dia punya akta lah. Jadi MEF boleh represent member companies in conciliation cases at the Industrial Relations Department. Okay. And then monthly meeting study free, and then training tadi kita ada specialist on IR, kita buat training in-house lah, public courses lah on IR. We also do IR and HR audit, not forgetting OSH audit as well. Yeah. Okay, now we move on to big data research and information services. Jadi it falls into this the category kita ada surveys and publications. We have resource center services as well as economic and labor data. Okay, ini cantik ni. Buku ni I just would like to share with you gambarnya lah, in which every year we came out with these salary survey books, which we have. The other one is for executives. Jadi these books are very, very valuable, and it is a good source of information because quoted by, so say for example, MOF, by MITI, by MIDA, contohnya. Jadi kita among our membership throughout the country. Jadi what we do is we conduct the survey, kita hantar the questionnaire, kita compile, kita tabulate, kita analyze, and then we come out with the results. Where by year end kita akan do we call it a media conference, where we will feature the highlights of our survey, termasuk juga what is the projection of bonus payment or the projection of increment of companies in Malaysia for the year. Contohnya macam tu. Jadinya in November last year lah, we did the media conference where we highlighted the findings of the survey books, and contohnya it was the articles were featured in the mass media lah in Malaysia. Dan kita juga ada fringe benefit survey, kita ada MEF analysis of CA's awards. Okay, now yang ini ialah buku-buku lain di mana dia termasuk di bawah IR series. Jadi ini contohnya yang the pink color tu, Probationers and the Law, that is the latest publication which we launched semasa we did our IR conference in November last year. And then buku-buku lain, tu buku Managing Discrimination at the Workplace. That is the reference that you should take, you should buy. Katakanlah, it relates to what Dato Jalal will be talking to you later on, cases of discrimination. Okay, now, lepas tu buku hijau tu, the practical guide. This is a very good book, which I would always suggest that as HR practitioners, this book should come handy to you. It should be right at your desk, because the name is practical guide. Being in the front line for many years, banyak kali kita juga terima questions from companies asking, Puan, can you share us the sample of contohnya surat, how to bagi warning letter ke, or maybe surat to transfer staff ke contohnya. Kita tak boleh bagi contoh because all those surat belongs to our members, clients, jadi they are highly confidential. So what the management did was we came out with this practical guide, and dalam buku ni all the templates of surat-surat semua memang ada. Jadi kita dah come out with second edition. Maybe kalau ada lagi pembaharuan, kita come out with third edition. And okay, for your information, our books are only available exclusively in MEF, tak ada di kedai buku. Okay, jadi members, non-members ada difference in the prices. Okay, now I move on to the training part, which we have a subsidiary which is called MEF Academy. So as an academy ni, kita dulu our training was part of the departments within MEF lah, contohnya dulu. But then we offered not only short courses, kita buat diploma program, degree program, master's program. where we collaborate with industry specialists, dan juga misalnya kita ada diploma program kita, executive diploma in IR misalnya, kita bergabung dengan ILO, kita ada modul from ILO. Dan juga kita juga ada macam misalnya program dengan UNIMAS, Swinburne University, Open University dan sebagainya to offer higher degree macam misalnya degree courses, master level courses dan sebagainya. And our courses are actually approved by HRD. HRDB, Jadi our courses are claimable from HRDC, Okay, now activities and services, of our academy. Of course, number one, we are specializing in HRM dan HRD. Jadi all our courses sama ada kita buat public courses atau kita buat in-house courses. Lepas tu kita juga boleh sit down with companies, kita bincang, the training need analysis. We can customize to the requirement, to the need of the company to come out, in accordance to your need. Jadi kita boleh buat macam tu, because kita ada specialist within our organisation to do that. Okay, lepas tu of course IR courses ini memang meletup lah, in which kalau kita buat IR courses memang selalu full house, because of course lah in Malaysia, I can say the IR, the best IR tu ada dekat dalam MEF ni, the IR consultants, the IR practitioners. We are here. And even our executive director, Dato Haji Syamsuddin Badan, dia pernah dianggap sebagai icon of IR in the country. Okay, now we are proud of that. Kita juga ada specialist in OSH, Jadi we can sit down with you to discuss on OSH punya requirement of your company, then we can come out with a module for you, okay? Dan juga yang lain-lain, as I mentioned, kita collaborate with industry specialist, bukan hanya HR courses saja, kita juga ada berkaitan dengan finance, taxation, dan sebagainya. Okay, lepas tu academic program, as I mentioned, kita ada diploma, certification, short courses, kita ada buat weekend class dan sebagainya, dan juga kita ada conferences and seminars yang di mana kesemuanya ini terbuka kepada members and non-members, akan tetapi of course ada harga yang berbeza. Okay, now other events macam orang kata picture speaks 1,000 words lah. Jadi kalau kita pergi, kita tengoklah the type of courses, the conference, Ini kita punya national conference audience ataupun participants, and then Datuk Syamsuddin, being the moderator for the with taxation punya seminar, where we every year we collaborate with the LHDN, and then kita also take part in exhibition dan sebagainya. Okay, kita ada two classes of membership. We call it ordinary, ahli biasa ataupun association membership. Kalau kata your company is a sendirian berhad, straightforward lah, an enterprise, a business owner lah, you ada, at least you ada employees, you can join us as a single company ordinary member. Okay, kalau kata your company has katakan affiliate company, ataupun your company straightforward, we call it, you are the subsidiaries. Dengan syarat, the subsidiaries or your affiliate companies, the HR functions of those affiliates, of those subsidiaries are centralized to the holding company. Apa-apa pun keputusan on HR refer to the holding company. You can opt to join as a group ordinary member. Sebenarnya group ordinary member, you all untung sebab you boleh rangkumkan, misalnya kata you ada 2-3 affiliate company, you kira head count, so that is considered one whole group, you pay the subscription and the whole group can become our member. Okay, jadi let me just explain to you shortly. Association membership ni, they are industry groups. Okay, nanti kita... Okay, now, annual subscription, ordinary membership, entrance fee RM500, that is a one-off payment. Ini macam processing fee lah. You join a club, ada processing fee kan. Jadi we call it entrance fee, a one-off payment. Okay. Annual subscription, dibayar tahunan. Okay. Selalunya kita start ikut calendar year. Okay. Akan tetapi now is already 18th of January. Katakan after this webinar, you would like to join us as a member. Katalah okay, kata betul lah Puan Hasina cakap. let's say kita make full use of the first year of our membership, maybe kita polish our documents, the letters ke apa-apa, kita tengok lepas tu, kita join the monthly meetings dan sebagainya, you know, or the email blast that she was telling us. Why not? Okay, give it a try. Kalau you join as a minimum member lah, misalnya kurang daripada 100 orang your staff, it is only RM1,000, which come out to lebih kurang RM4 per day je, ataupun dalam RM87 macam itu. Itu pun kan. Lepas tu maksimum ni RM6,000. Macam mana we come out the maximum? Okay, you see the formula here. Because our subscription is being determined by the total workforce. Okay. Jadi kalau you ada, contohnya you ada 20 orang, okay. You jangan guna formula ni. The first 100 employees RM10. Jadi 20 orang kali RM10, 200 je. Sebab minimum kita 1,000. Kat situ ada tulis 1,000 Okay, now. Jadi as long as below 100 orang, memang RM1,000. Be it 80 orang ke, you ada 5 orang ke, RM1,000. Kalau you melebihi 100 orang, jadi you pakai formula ni. Katakan you ada 120 orang, the first 100 RM10, dah 1,000 The second 100 tu 20 orang tu kali RM8, jadi RM160. RM1,160. That is your subscription for the year. Okay, and then you tambah the tadi entrance fee, a one-off payment. Jadi next year bila you renew, it will be depending lah kalau masih 120 orang. Kalau masa you renew tu dah kurang daripada 100 orang, you bayar 1,000 saja. Tapi kalau macam contohnya, you masuk contohnya bulan 2 this year, you bayar full, it will be from February this year sampai February next year. Untuk 2024, your subscription will be prorated. Okay, only for that year. Orang kata after you reach your first anniversary with MEF. Lepas tu 2025, nak sambung, it will be from 1st January sampai 31st December. We follow calendar year. Okay, jadi saya harap faham. And kita ada association membership, just cerita sikit lah pasal ni. As long as katakan your particular company is under the umbrella of your industry group. Contohnya macam ini. Okay, ni saya tunjukkan kita ada dalam 28 industry groups which are our association members. Okay, misalnya kata your company is a member of katakan Malaysian Plastics Manufacturers Association. Contohnya dekat sini kan. Okay. Jadi kalau you di bawah MPMA, you bahagia hidup sebab your subscription will be discounted 20%. Ini untuk yang kategori yang saya highlight color yellow tu ajalah. Kalau tidak, you join us as ordinary member, you bayar penuh lah RM1,000. Kalau you punya employees kurang daripada 100 kan. Kalau employees you kurang daripada 100 tapi you di bawah membership of any one of these associations, you dapat diskaun 20%. Inilah antara 28 industry groups yang currently our members. Okay, now. Jadi ini tadi explanation lah, ada 20%. Okay, now. Sekarang ni membership kita, association yang ordinary, growing lah, slowly but steadily lah. Jadi kita as of penghujung tahun 2022, kita ada dalam 6,500 lebih lah ordinary members. Okay, now. Di mana our members sebenarnya being di seluruh Malaysia, we cover around 2.9 million private sector employees in Malaysia covered by MEF membership. Okay, now. Ini ialah the taburan how our members scattered throughout the country. Jadi kita ada, you nampak mana logo-logo MEF ni, where the location of our regional offices lah. Macam yang ni di Penang ni kita ada dekat mainland, jaga the northern region office, in which they cover Perlis, Penang, Kedah. Okay, Perak kita ada satu di Ipoh ya. Tu, and then cover Perak member saja. Central region ni ramai lah sebab kita ada kita cover KL, Selangor, Putrajaya dan Sembilan Melaka. Majority kita di Central region. Lepas tu kita ada Johor office, kita ada Kuantan office yang jaga East Coast region, kita ada Kuching dan juga di Kota Kinabalu di Sabah. Okay, now. Jadi itu sahaja from me for the time being. Kalau ada any questions, any clarification to be made, nak tanya, ya, tolong email to us, or you can call us at any time at this general line. You ask for membership team. Okay, saya and my team will be delighted to answer your queries. Then we look forward to see you soon as our member, inshallah. Okay, over to you, Cik Zakri. Thank you.
Thank you, Puan Hajah Haslina, for the very clear and comprehensive presentation on the role and function of MEF and the many benefits. So I would strongly encourage companies to sign up with MEF so that we can be a stronger community. So if you have any more questions on membership, please save them for the Q&A session later, or you can begin to post this in the Pigeonhole platform link that you can find in the chat box. So without wasting more time, for our next presenter, I'm pleased to invite Yang Berbahagia Dato Jalaldin, MEF Senior IR Consultant, who will speak on a very hot topic, which is discrimination at the workplace. Most of you may not be aware how this may impact your company. So let's hear from Dato Jalaldin on what is discrimination and how it could be dealt with at the workplace, and most importantly, what employers should do to educate their staff on the issue of discrimination. Dato Jalaldin, the floor is yours.
Thank you, Cik Zakri. Good morning, everyone. Assalamualaikum to the Muslim members. I'm tasked today to talk on what is known as the discrimination at the workplace. Why we do so? Because of Section 69F of the amended, which has already come into force on the 1st of January 2013. And it's the usual case that people will not be bothered with and pause. Then there will be scattering around to find out what is Section 69F, because the Section 69F does not create an offence in the first place, but it says that the Director General may come and investigate and then may issue an order. And if you fail to consider the order or implement it, there is then the punishment of, number one, you violate the order, then there will be a sort of punishment that you will have to pay for every day of non-compliance until you comply, and you can show proof that you have to comply. So therefore, the most important thing is that what do we do to prevent the Director General from investigating? Because the word used is that the word that is being used is may. But in the first place, everybody is asking, what is discrimination in the workplace? What the hell is discrimination? Can we share the slides? Ada slides tak? Sam? Mana slide ni? Sam. Share the slides. Right. Yang jelas ni.
Yes, next saja lah.
Next tu tekan mana? Next.
Just tekan arrow next.
Okay. Okay. Now, the most important thing is that what then is discrimination? Because if you look at the explanatory statement to the the EA Amendment Bill 2022, and also subsequently the short title or the preamble to the Act, it clearly says, the explanatory statement state that why the amendment need to be done is because Malaysia intends to comply with international standards and practices as required by the CPTPP. We started with the TPP, which we signed earlier. So the purpose is to provide the protection against discrimination. One of the things that the Amendment Act was supposed to do is to protect against discrimination. Okay. Therefore, if we look at the Act, which has already been tabled and passed in Dewan Rakyat on the 21st of March, Dewan Negara on the 30th of March, Royal Assent on the 24th of April, gazetted on the 10th of May, and subsequently given the date of enforcement by the Minister, 1st in September, and then it was extended to the 1st of January this year. So the explanatory statement clearly states that one of the purpose of having the amendment is to protect against discrimination. Right? What then is discrimination? Because we see that, number one, the rule is that the EA is amended so that our standards, the standards of practice with regards to discrimination, must be according and in compliance with international standards. So the international standards is one of it is by as stated in the international the ILO, International Labour Organization, and the International Labour Organization has issued via Convention 111. So under Article 1 of the ILO Convention 111, employment and occupation, the term discrimination and occupation includes, it does not give you a definition. Also, you look at the Employment Act, also does not provide any definition of what is and what is not discriminatory. Therefore, we have to go back to the ILO Convention, which states that any distinction, exclusion, or preference made the basis of race, color, sex, religion, political opinion, national extraction, or social origin, which has the effect of nullifying or impairing equality of opportunity or treatment in employment or occupation is this. So if the act of distinction, exclusion, or preference on the basis of race, color, sex, religion, political opinion, national extraction, and social origin, which has the result of nullifying or impairing equality of opportunity or treatment in employment or occupation as may be determined by the member concerned. So as is this, we look in our section 69F, subsequently we will look at it. There is no definition, or even under the Employment Act, there is no definition of what is discrimination. And therefore, we will have to look at the international standards. Then we will look at the relevant laws in Malaysia, which states what is discrimination. As it is, employers, why we have this seminar is just to educate and explain to you what you have to do so that the DG will not come to you and investigate on complaints of discrimination. because before you can investigate, you must first establish that there is discrimination. Now, under Article 1(2), any distinction, exclusion, or preference in respect of a particular job based on the inherent requirements thereof shall not be deemed. So one is deemed, the other shall not be deemed to be discrimination. Therefore, we have to be very clear. If it has the effect of nullifying or impairing equality of opportunity or treatment in employment, then it is discrimination. But if it is based on a particular job or inherent requirement thereof, it is not discrimination. So employment and occupation includes access to vocational training, employment, particular occupation, and terms and conditions of employment. So they will also look at your terms and conditions of your employment, i.e. your employment letter or your offer letter, whether there is any form in your offer letter with regards to excluding people of a particular race, color, sex, religion, or political opinion, national extraction, or social origin, then it is discrimination. So you cannot discriminate. They take action to pursue national policy with a view to eliminating any discrimination in respect thereof. So this is the articles in the Convention 111 will be our guiding principle as to what amounts to discrimination and what is not deemed to be discrimination. Under the ILO Convention C111, C stands for Convention, Discrimination, Employment and Occupation Convention is based on race, color, sex, religion, political opinion, national extraction, and social origin impairing equality of opportunity or treatment in employment. Malaysia, however, did not ratify. We did not ratify C111 and Convention on the Elimination of All Forms of Discrimination Against Women, or what is known as CEDAW. However, the requirement by the ILO is that the ILO, based on Declaration on Fundamental Rights at Work, says otherwise. It says whether you ratify or you do not ratify, and you have to take steps to ensure that there is no discrimination. So whether you ratify or you don't ratify. In this case, we did not ratify C111 and also the Convention on Elimination of All Forms of Discrimination Against Women, 1980. However, we will have the Convention on Declaration of Fundamental Rights at Work, right, which require us, and a good example of question of elimination of all forms of discrimination against women is on the provisions with regards to women working at night. That one now we have deleted from our existing EA. And also with regards to provisions of maternity protection, we have already aligned in accordance with ILO Convention number 183, whereby the maternity leave has been increased from 60 days to 98 days, i.e. the convention says 14 weeks. Since the ILO Convention says 14 weeks, thus our 60 days have to be extended because we have signed and be bound by this TPP and the CPTPP that we have to follow international standards, i.e. if the convention on maternity is 98 days. However, Singapore has only 84 and Thailand only 90. We have also the next convention, the ILO convention, that is the convention 100, ILO convention 100, where Article 3.3 of that convention explains that different rates between workers which correspond without regard to sex to differences as determined by such objective appraisal in the work to be performed shall not be considered as being contrary to the principle of equal remuneration. Because under Convention 100, the ILO Convention says that same salary must be given to workers performing the same jobs, irrespective of their gender. So whatever a male employee gets, a female employee also gets. If a female employee gets less than a male employee, then it is known as discrimination. Our laws also, you see Article 8 of the Federal Constitution also prohibits discrimination based on gender. Article 8.2 clearly says, clearly states that you cannot discriminate based on gender. Then we move on. So we have gone through, gone to Convention 100 and 111. The other ILO conventions is Convention C98, Convention 98, where employees have the right to organize and do collective bargaining. So if you do not allow them to organize or form unions, or you don't allow them to attend and do collective bargaining, and not only that, you have to see that in the convention also, it states that you should not prohibit them from bringing all matters pertaining to terms and conditions of service at a bargaining session as evidenced by Section 13 of the Industrial Relations Act, which was amended in 2021 in compliance with Convention 98. Now, under Convention 98, under our present law, if you look at Section 13 of the the Industrial Relations Act, prior to the amendment of the IRA in 2021, there are certain prerogatives or certain matters that are considered to be the company's prerogatives, i.e., for example, the question of transfer, the question of promotion, the power to organize itself. All are matters which cannot be bring or discussed during a collective bargaining session. Now, in compliance with Convention 98, we have Section 13.3 has been amended. Now there is no holds bar. They can bring anything to the bargaining, to the CA negotiation related to terms and condition of service. So we have to be very careful. Now, when you do CA, there is no holds bar. So for those who have CA negotiations as of 1/1/2023, you will have to be very careful, because now the union can bring anything to the bargaining table, and you will have to then justify as to whether the articles that they bring in should or should not be discussed. Therefore, please, if you have any doubt, come to MEF, because we have experts. We have experts pertaining to collective agreement. Now scenario has changed. You cannot stop them from bringing issues which were formerly under Section 13.3, which were known as the company's prerogative. Then we have Convention 105 and Convention 29, this is pertaining to forced labor, which is also covered under our amendment. It is amended under section 90B, and we can have a session later, which is in the pipeline of the issue of addressing, preventing, eliminating, preventing and eliminating forced labor in the workplace. MEF also was involved with the ILO in preparation of the template pertaining to harassment and especially sexual harassment in the workplace. So these are all in compliance with requirements, especially on forced labor under Convention 105 and Convention 29. We will not be addressing that issue because today we are only concerned with Convention on Discrimination, especially 111, 100. And we have also Convention 87. This concerns the right to form trade unions. Malaysia has not ratified this convention. However, it allows employees to form union and join union irrespective of industry. Now they say that the international standard is that you cannot limit unions participation or employees joining union, limit it to their own industry. So we will have a union across the board. For example, now if people in the metal industry would now want the union, the rubber union to be in their organization, then so be it. And these are all in the pipeline pertaining to the Trade Union Act, which we are all awaiting, whether it is going to be brought up at the and passed at the coming session or subsequently anytime this year. And then there will be multiplicity of union representation in the company. That to happen, it is considered under Convention 87 a violation of the convention and discrimination against the workmen. So we await what is going to happen to the oldest law. People ask me what is the oldest law in Malaysia. The oldest law in Malaysia is the Trade Unions Act because it is known as TUA, T-U-A. It's the oldest act in Malaysia. We hope also that we will all be consulted and please get ready. If the law pertaining to the trade union is subsequently amended, then you will have no choice but to have separate CAs, or it is said that the proposal is one of the many trade unions will be the leader, and you will have to then have CA with that representative of all the unions. Then we have Convention 182, which is about child labor. This we have implemented because under the EA, we have deleted Part 10, Sections 45 to 56 pertaining to child labor. So there is no more discrimination on child labor because we have amended our act. So then what is the forms? What are the forms of employment and occupational discrimination? Under international standards is given into three phases: pre-employment, during employment, and post-employment. However, Section 69F for Malaysia, we only adopt the one pertaining to during employment. So pre and post-employment is not of our concern because that is not covered under Section 69F. So if you follow international standards, pre-employment, there should be no discrimination in hiring. And the hiring must not be based on race, even the advertisement and interviews and selection process also cannot be based on race, religion, color, uh, your ethnicity. Those cannot be. But then the next thing is that during employment. Now, what is considered to be discrimination during employment? And the international standard says you must have job specs. Working hours must not discriminate on gender, i.e. that's why we have deleted Part 8 of our Employment Act, Sections 34 to 36 and 44A pertaining to women working at night. So now we are compliant in the sense that as far as during employment is concerned, there is no gender discrimination. However, there are certain other things, i.e., we have discrimination based on reason to terminate, i.e. now under the present act, EA has been amended that you cannot terminate an employee on the basis of her pregnancy, except if she has committed a misconduct or the company is closing down. And therefore, you must also now have a policy pertaining to pregnancy. So if there is no non-performance, you cannot dismiss her. And if she is subsequently on maternity leave, you cannot implement the PIP, and the PIP then will have to be extended until she comes back. Also, the discrimination in international standards is that promotion cannot be based on religion, gender, marital status, nationality, membership or non-membership of a union. So you have also to be careful that you must have a promotion policy which does not discriminate the employees as far as their promotion is concerned. Then there is also a guideline on what is known as decent work convention. Right? Now, under this decent work conventions, which is also under ILO, on the ILO conventions on decent work, which companies need to refer, and most of which concerns the following. Number one, work and wages. Right? Have also Malaysia have also amended our law when we amended the Minimum Wage Act. So it says also with regards to work, i.e. the ILO convention says you cannot work more than 45 hours a week, which we have also adopted, and it is in our Employment Act. If you don't follow the minimum wage or work hours is more than what is permitted, then you are being held to be in contravention of the decent work conventions, and you will be seen as to be discriminating your employees. Also entails employment security, job security, as per Section 10, subsection 1 and 2 of the Regulation 8.1 and also Regulation 8.1 of the Employment Regulations 1957. So if for example, you do not provide security of tenure, that's why we refer to our cases of contract of service. So all for contract of service, there must be security of tenure in the sense that they are made permanent employees. And if you have fixed term, then the fixed terms cannot be renewed automatically every year for years and years. Because as far as fixed term contract, it must be for a fixed term and a fixed purpose. For clarification on that matter, please refer to Ahmad Zahri Mirza against AIMS Cyberjaya. And also because fixed term contract has got expectations. So if you have been renewing the contract over and over a period of time, then they are supposed to have legitimate expectations as decided in the Hanchang High School's case and not versus and the case of Chandra Muzaffar. That one you can refer subsequently to the case laws. And also there is also a discrimination with regards to OSHA, Convention on Health and Safety, as per the OSH Amendment 2022. So if you don't provide, it will look as if it is discriminatory. If you provide health and safety for certain group of people and not for other groups of people, you better have justification for doing so. Otherwise, it will be seen as discriminatory. However, the OSH Act is yet, OSH Amendment 2022, yet to be given the date of enforcement. So please get to know the amendment, because once enforcement is given, then you will have to abide by the amendment, OSH Amendment Act 2022. And then also actions against trade union activities. So you have to be very careful if you don't allow them to go for meetings, don't a replacement on their off days. This also will be seen as discriminatory according to international standards. So we have to know that discrimination is not only with regards to gender, but also to give trade union rights to establish a union and also to collective bargaining. As we have stated earlier, there were Section 13.3 of the IRA has been amended, and now you must let open to them to have discussions on all matters pertaining to terms and conditions of service. And the other forms of discrimination, the international, the ILO convention, is discrimination as against women and men, but on condition of sexual harassment. That is why you say that we have, in fact, Malaysia is even way ahead. We amended our act and imposed conditions against sexual harassment in 2012. Now it's already 2023. Address the issue of sexual harassment and also the ILO sexual harassment is deemed to a form of discrimination. Therefore, you please also look at Amendment Act A1419 and the latest amendment that we have just passed in 2022 pertaining to sexual harassment by deleting Section 81G and adding a new Section 81H, which mandates to say that you shall raise awareness on sexual harassment. So Section 81H is in line with Chapter 19 of the ILO, Item 19.8 on awareness. So under the ILO Convention, the responsibility of every employer to raise awareness on sexual harassment. And we have adopted that by adding Section 81H to our EA as effective of 1st January 2023, companies must take action to create awareness pertaining to sexual harassment. There is also a Sexual Harassment Act 2022, which has been passed by Parliament, but yet to be given an enforcement date to establish a tribunal for sexual harassment and to award compensation to victims of sexual harassment. So your employee may not, the victim of sexual harassment in the company may want to take, may only not only report to you, then the companies will have to investigate under section 81 A to section 81 F. Those are all the procedures that you have to follow, because sexual harassment is a form of discrimination against an employee during her and it is a form of discrimination in the workplace. Or they may choose not to go through the company, but to take an individual action of a tortious action. This tortious action, as in the Ridwan's case, and also now that they can go straight to the tribunal. They say they complain to the company, no action is taken, and they don't. Even if action is taken, it will ultimately embarrass them, go through a lengthy process of DI, and subsequently they will be grilled by the defense counsel in the industrial court. And therefore, to avoid all this, they go straight. They are now under the Sexual Harassment Act 22. Your employee can go straight to this tribunal, which is going to be established under the Sexual Harassment Act 2022. And therefore, you have also to be prepared, because whether the company would want to send a representative to be present there as amicus curiae to protect the interests of the company. Because they will, under this act, there is compensation that the court can award. As it is, you go to the industrial court, at most, the one and only punishment is dismissal of the perpetrator, of the one committing the sexual harassment, but nothing is given to the victim. That is why now you have this tribunal, and the employee then must be given time. For them to appear in the tribunal, the sexual harassment tribunal, and if you do not, then you are also guilty of discrimination. The last of the form of discrimination in the workplace includes domestic violence. So if your employee, if you have two employees in your company who are married, one hits the other, and you don't, the victim reports to you, you have to take action with regards to domestic violence, because it is something which will at the end involve the company's good name, reputation, and image. But however, the only problem with with domestic violence is that it has to be read together with the penal code, and most of the time, after they have filed a complaint, you start investigation, then they get back together and they say they want to withdraw the complaint. Then we are caught in between. So let us now look at the amendment itself. The amendment, the new amendment, section 69F. The 69F, there is no definition of discrimination in employment. First, secondly, it only states that DG may inquire. You see, the word here is may, and not to say may means they can only inquire in the month of May. may means is discretionary, then it will depend whether the DG would want to investigate or do not want to investigate. If what the companies should do is, we must make sure that the discretion is not being used, because we must be the people who takes proactive actions, which I will discuss later, so that the DG may not use his discretion. What then is discrimination in employment in Malaysia? Just now we have looked at international conventions and international standards as a guide. Now in Malaysia, simply put, if the action flouts any law, then if it concerns religion, race, gender, descent, place of birth, or your ethnicity, then it is discrimination. The highest law in Malaysia is our federal constitution, and the Article 8(1) prohibits discrimination in employment solely based on the ground of religion, race, gender, descent, place of birth, in the appointment, appointment of any office or employment. Therefore, if this is where, although we adopt 69F to say it is only discrimination relating to discrimination in employment, but the federal constitution under 8(1), which is the highest law in the country, prohibits discrimination in employment based on ground of religion, race, gender, descent, or place of birth. And also, out of the Beatriz Fernandez case, Article 8(2) of the Federal Constitution also prohibits discrimination based on gender. We have to look at court cases. In Dato Harun Haji Idris against PP, Sufyan, the Lord President then, held that the first question is the law discriminatory? If not, it is good law. Similarly, when we have cases of discrimination, then we will have to look at the complaint, whether that complaint breach of any law. If it is in breach of any law, then it is discrimination. If it is permitted then it is not discrimination. Putting all those words would only lead to people asking more questions. So we have to look at the case. The most celebrated case on discrimination is that of Beatriz Fernandez against Mas, where Beatriz was a flight stewardess for 11 years. She was bound by a CA between Masiu and Mas. Clause 2, para 3 of the CA required an air stewardess to resign if she became pregnant. So Beatriz became pregnant but refused to resign, and her services was terminated. He argued that the Court of Appeal is unconstitutional. She argued that the CA is unconstitutional as it violates Article 8(1). The Industrial Court felt otherwise and held that the CA was binding between parties and enforceable, and held that the dismissal was with just cause and excuse. The High Court affirmed the decision of the Industrial Court. The Court of Appeal ruled that Article 8 fell within the domain of public law, i.e., the contravention of which only applies to public authority, i.e., federal or state department or its agencies. As Mas was not proven to be a government agency, one does not apply to Beatriz. The federal court interpreted equality to mean that it was measured against rights of other flight stewardess, i.e., you say it has to be apple as against apple, orange as against orange. You cannot use this provision as one fits all, because they say it is only applicable to flight stewardess only, and it was not discriminatory because of the dangers of having a pregnant stewardess to be on flight and the risk that is attached to it. And therefore they say, if you discriminate or you have this CA which is only applicable to stewardess, it is not then, because you remember the international convention says if it is job requirement, it is not discriminatory. And in this case, they said that it is not discriminatory as it does not apply to the same categories or the same categories of others working, i.e. if you are administrative staff, you don't have to resign because there is no risk involved. And therefore, he says, since this is equality among equals, then it is not discrimination. Then we look at another case. I'll only give you a few. 3 cases. We have 3 cases. The second illustration is in Nur Fadilah Ahmad Salikin against Syed Basirun and others. Nur Fadilah was a guru sandaran tak terlatih and was asked to collect a placement notice. Her placement was revoked when she was found to be pregnant. She sought a declaration that the revocation was unlawful by virtue of Article 2. So by the time Nur Fadilah filed her case, Beatrice's case was addressed by amendment to Article 8.2 that there should not be any act, transfer, or like Beatrice's case, you are asked to resign because of your gender. Of course, male do not go for maternity leave. Only those who are female stewardess. So they said you cannot discriminate. If you cannot discriminate gender, then you have the day amended Article 8.2, and when Fadilah's case came to court, Article 8.2 was already there, that there should not be any discrimination based on gender. So in this case, she went to court for a declaration. The High Court declared that the revocation was unlawful. However, the reason that was given was that it was unlawful not only because of Article 8.2, but also because of CEDAW. You have seen that as the Convention 111 and the Convention against the elimination of all forms of discrimination against women. So, and they say based on Beatrice's case, it is different because here it involves the education department, which is a public body of the government. Therefore, they said this case, there was a breach because when she got the placement notice, she was already given a job and given a promise, and that placement itself makes her having a permanent employment. Therefore, there was clearly a breach, and therefore the court ordered a declaratory order, and damages amounting to 300,000. However, the ministry challenged the declaratory order, and the Court on judicial review upheld that the revocation was illegal However, it stated that CEDAW was not recognized because we have not ratified it. Since we did not ratify it, it has no legal basis. Then what happened was, since 182 Article 82 has been breached, but nothing which the court feels has not been recognized. So they reduced the damages by 90% and were awarded Nur Fadila damages amounting to $30,000. So of course, Nur Fadila felt that she was denied justice, and she appealed to the Court of Appeal. The Court of Appeal affirmed the High Court decision and also the declaratory order that the revocation of the placement notice was wrong in law. It is a discrimination, violation of Article 82 of the Federal Constitution. Therefore, the Court of Appeal increased the damages from 30,000 to 40,000 and awarded $10,000 in cost. Then we have the next case. The next case is AirAsia against Rafiza Shima Muhammad Aris. Rafiza joined AirAsia and signed a training bond that she will not get pregnant during training. She got pregnant and was dismissed. The High Court allowed reinstatement, but the Court of Appeal reversed it. The High Court's order pertaining to allowing, again based on CEDAW. The Court of Appeal says since Beatrice Fernandez clearly says that one only applies to public bodies. Similarly, AirAsia, as per the case of Beatrice Mas, is not a public body. Therefore, the principles that were applicable in the earlier case of Nur Fadila Ahmad Salikin did not apply. So they rejected the statement and upheld that the dismissal was with just cause and excuse. They also held that there was an agreement, and this agreement was between Rafiza and AirAsia. It was a private agreement between two private bodies, and she was supposed to honor it and resign. This is because of again the question of job requirement. The job requirement for her during the training as a trainee would need her not to be pregnant. So therefore, as far as we are concerned, we still await, now that we have 69F, what would 69F do? The position will change or not, it is still judicial interpretation. We have also in our Constitution Article 5. Article 5 provides that the right to life includes that guarantees against arbitrary dismissal. Therefore, if you arbitrarily dismiss your employee, it is also a form of employment discrimination. The DG may inquire under Section 69F1, right? The word may, I stress the word may, if you had dismissed these people based or in contravention of any conventions that we have stated earlier. As a guarantee under Article 5, employers too cannot discriminating by terminating female employees during pregnancy. Also in contravention of Article 8.2 on gender discrimination, i.e. you have VSS. If you only says in the VSS, I only want to terminate VSS to the male employees, not to the female employees, that also discrimination. Right? We see that if you contravene any of the conventions that we have stated earlier, then they may report to the DG, who then may investigate into the matter, and if the termination is arbitrary due to race, religion, ethnicity, gender, then that termination will be held to be void due to discrimination under Article 5 of the Federal Constitution. We have also the new Section 41A on the restriction of terminating a woman during her pregnancy if the reason is based on she taking a lot of medical leave during her commencement or during her work due to pregnancy. So if it's for any other reasons, a question of performance, because if it is related to her pregnancy, you will, if you terminate her, then that is discrimination. Now, we all know under 69F, the DG may investigate to complaints of discrimination. The procedure for disposing questions arising under Section 69F in section is stated in Section 70 as to the DG's inquiry. And Section 73 is the powers of the DG to issue prohibitory order to third party whenever the DG shall have whenever the Director General have the power under 69F against any employer or any person liable for the payment of any sum of money to any employee or contractor of labor. They can also, the DG also can, if there is any breach on discriminatory reasons, order that payment be made to that from the day the breach was committed. And then you have the DG's order pursuant to Section 69. Number 1, there is a complaint. Number 2, DG inquires to the complaint, and upon receiving the order as per Section 6, then issues an order. And then after that, the order will be given to the company. A company comply. If the does not comply with order under 69F1, the company commits an offence, and if convicted of that offence of non-compliance, the company will be liable to a fine not exceeding 50,000 ringgit. And if the discrimination order to be addressed and resolved is not complied with, and the offence is continuous, the company shall, this one is shall, not me, shall be liable to a daily fine not exceeding 1,000 ringgit for each day the offence continues after conviction. Under section, then if you are not happy with the DG's order, you can appeal. Under Section 77(1), EA allows the company to appeal against the DG's order made pursuant to Section 69F to the High Court. The appeal under Section 772 shall be the procedure in a civil appeal. What is our advice to members? Section 69 operates when the DG receives a complaint and investigates. Therefore, the companies have to be diligent and take appropriate actions. These are actions, the actions pertaining to proactive to ensure that the DG will not use its discretion. Therefore, to take proactive steps, the following are being suggested. Number one, you must have a policy on discrimination, i.e., there must be a policy statement that the company does not practice discrimination in employment. You have a complaint and grievance procedure. There are decent work agenda or decent work templates, which we have. And if any one of you would want to look at it, we can have further discussion subsequently. You can make an appointment and see me, or you can use our services pertaining to review of your handbook so that it is in compliance with the requirement pertaining to discrimination in the workplace. Then you have to give assurance to and create awareness to your employees that the company, that they are free to raise complaints or issues on discrimination in employment to the company. Then you have a workflow on cases of complaints of discrimination and record outcome. Then you can inform the DG that action has been taken on the matter and matter resolved. Just in case someone goes and make a complaint to the DG, then the DG will say the matter has been looked into and agrees with the decision of the company, then the case will be closed. We have, as already stated by Puan Haslina, MEF has a book on managing discrimination at the workplace. So if you want a copy, if you want to have a look, you can always contact the membership, and also we will assist you. We also have what is known as the Responsible Business Alliance Code. And this has been in the a code that has been in practice. And if you want also to have most welcome, you can come to MEF and you can buy the book. All right. So what then must you do? And why do you need to do the actions that we have suggested to you? What rationale in support that you take this proactive. The first is once you have or you have taken the steps, i.e., you put a redress, the redress procedure. There, in the redress procedure, there is legal basis to say you cannot go straight to the DG. You have to come through the company and use the grievance procedure as provided by the company. Otherwise, then they will go straight to the company, and then when the DG and the DG comes down, and you are caught with your pants down. Therefore, to ensure that no complaints will go direct, that will come to you, you please in your handbook have a template and inform your employers of a redress procedure where they can come and complain. And if they say allegation is against the superior, then the complaint should not go to the superior. It should go to the HR. If the HR personnel is the one that is involved, then they may be to raise their complaint to even the CEO. So what you do is you have a redress procedure in your handbook and inform your employees that here there is a redress if you feel that there is of the employees during the employment. So you have to form, you can come so that the company can verify whether there is basis or there is in fact discrimination in the first place. And if there is, then the company will redress the issue. Then you have a mechanism of how you redress, i.e., or the process of investigation, the process of funding, that whether there was or not, and you have to explain what do you mean by discrimination, which is limited only to that of race, religion, your ethnicity. So there is a mechanism that is within the company, and if the company finds that discrimination has been committed, then it must also assure that there is all the benefits when there is a breach. You must also explain and create awareness among your employees of what is and what is not discrimination, so that at least they understand the meaning of uh, uh, discrimination, where if it is for your job specification or requirement of your job, it is not considered as discrimination. Then this is most important, because if they complain to the DG, an investigation is done by the of the company will definitely be affected. And words will go around that you are a company practicing discrimination, which is bad for the company's image and reputation. And also, you have to put in your template that action will be taken against perpetrators, not only those victims of discrimination, but the people who perpetrated the discrimination also, action will be taken. And also state that also to the employees, that if they have any doubts, please clarify with HR complaints, because if subsequently the complaints on discrimination prove to be vexatious or abuse of process, then action may be taken against people who lost the complaint. Once you have all this in line, or all this within your handbook, there is no necessity for DG to investigate. And even if the DG were to investigate, then you have already got the answers. At least now, even if the DG comes, you can show that it has been taken into, and action has been taken, it has been investigated, there is no discrimination in this case, and matter closed. Therefore, there will be no need for the DG to investigate. On templates, you can come. We provide services. If you want us to to review your handbook, or to provide a template, we have the services. We have the templates to assist you. But basically, these are the steps that has to be taken to avoid Section 69F to operate. So prevention is better than cure. We make sure fully aware of things and have them under our control. Otherwise, if you do not have all this mechanism, then it will only lead to the DG coming in, and at that time, it's too late for you to do anything, because they will have their own investigations, they have their powers. You cannot give any. So, as an advice, I hope you do. If you have any doubts, if you have anything that you want to ask, please come, because MEF is there for you. You are our members. You are our members, and we are here to serve you. And therefore, in doubt, like my father usually says, you must always believe your beliefs and doubt your doubts. Never doubt your belief or believe your doubts. So, my short talk. And if there is any other questions, please come to us. It is better that we meet face to face, so that some explanation can be done online. Some explanation we'll have to look at your documents and whether it is sufficient, or we don't have documents, we'll help you to prepare a template. because this is a new provision. It has never been there all along. Now is the first time people are looking at this discrimination. This is not what the government wants, but this is something that we have to follow in order to continue trading with the partners in CP, TPP, and all the TPP 12 countries. So it is of national interest that such a amendment is made. We have to live with that amendment. It's only we are not breaking it, but we are not circumventing it. We are preparing you to face it. So let's all work together. Then if you have any doubts or anything that you want to ask, please you can come to me and see me. We can go through your documents and help you to cover in your handbook all the provisions that is covered under 69F to ensure that you have complied with all the requirements under 69F on discrimination, and that the DG should not bother you or come to investigate. So again, I thank all of you, and I hope that we have more sessions like this from time to time. I thank also the membership for giving me this opportunity to be of assistance to all our members, and hope that we will sit together. Kita boleh ada percambahan pemikiran, or like the present PM saying that we should have a perkampungan, so that we can exchange views. And most important is that we hope that none of our members breach the question of discrimination. We spend the 50,000 fine and the daily fine of $1,000 for every day of non-compliance. So thank you very much.
Thank you, Dato Jalal. I think that was a very comprehensive and interesting presentation. And I'm sure that were many things that were highlighted that we are not aware of. And but I think your presentation was very clear, pasal apparently not many questions have been submitted through the pigeonhole. So for those who are participating in the webinar, you still can post your questions in the pigeonhole or in the chat box. But meanwhile, maybe I can ask Dato Jalal on a matter, maybe it's related to discrimination, but I think in view of the latest amendments to the Employment Act yang came into force this year, in relation to the maternity leave, kita extend maternity leave daripada 60 lebih hari sampai 98 hari, and then now there's also a provision on sexual harassment in the Employment Act. How is this, could this be related to gender discrimination in terms of maybe employers are more reluctant to recruit women now into employment in view of the cost implications due to these new amendments to the Employment Act?
Well, if we look at this, these are all we are moving towards international standards. Any country would want to move and ensure that their laws. We have to understand that we also on the sidelines has signed an agreement with the US, which is known as the US Labor Consistency Plan. So where our laws also, if we want to trade with our labor laws too, must be consistent with US labor laws. So these are all questions of trade, question of national interest, whether we want to be global or local will depend on employers, because these are opportunities open. With regards to sexual harassment, it's nothing new because we have already adopted it since 2012, except that the new provisions pertaining to discrimination of gender is only pertaining to dismissing the employees during the pregnancy. And this is something which is obvious to everyone, that somebody who is pregnant will definitely be deemed, and undergo a lot of changes They may be taking a lot of medical due to morning sickness. Therefore, this must be recognized. It's not to say that we want or we don't want, but we have also a new provision there that even though we give 98 days of maternity leave, we have also a balanced provision, the provision where they can return back to work early. Even as early as 2 weeks or 3 weeks, they say, no, I don't want the 98 days. Right? I want to come back to work because of the job necessity or whatever it is. We allow, but the only problem is that then the employers will have to decide whether they want them back to work, because they will be entitled to two. Number one, their maternity benefits they still get for the 98 days, irrespective of whether they join back the next day or the day after. They are still entitled to the 98 days benefit. And on top of that, because they return back to work, they receive their monthly salary. So if employers feel that they need this employee to come back early, for example, like you are having closing accounts, you need this person back. You can't wait for 98 days. Then there is this provision, to be fair to both sides, employer and employee, that the employee can come back at any time. But then the employer must still bear the cost. The only thing that the employers are not happy is that because now you have two salaries. The benefits dia dapat, gaji dan ni pun dia dapat. But any law that we make, there definitely will be flaws. They will definitely not make everybody happy. Our job as employers is to ensure that once laws are being passed, we adhere to the law. We don't break the law, but we help you to circumvent the law. So that is where MEF comes in. We help you to interpret. We help you to prevent. Preventive action is better. That is why we are having this seminar today, is because we want to advise you, don't keep quiet, don't stay. There must be a proactive action. If they say you investigate, we will have policies, we'll have to take actions to ensure that the DG never come or step a foot to our company and meddle with our affairs. The DG will be happy because they too have got a lot of other works to do. The only thing is that normally the problem with companies is that they do not document. So documentation is very important in this case, because if there is this grievance procedure, the decision of the courts has always been, you use your rights first. If you have not used the rights, you cannot go to the DG. So since the grievance procedure is there, please use your grievance procedure. That's why we need to put all these things in place so that they can't even go to the DG. It's not that the DG may investigate or not. The DG cannot investigate because the employees will have to come first to us. And we can always settle the problem at the butt. We do not wait for it to grow and grow and grow and become a tree. Then it will be difficult for us. So this is addressing issues, and we are giving, this is why we need more companies to join MEF. Therefore, there will be a standard practice among the industry, among all companies, using the same template. We work together for the betterment of all the members of MEF. And then it's easier to speak with one voice. The more we have, the more people will listen to us. If you are just representing 1 or 2,000 people or 2,000 employers, the government may not give you an ear. But if you are representing 10,000 companies, and you have 100,000 workers under these companies, I don't think the government would not consult you or not listen or give an ear. So that's why we hope we are observing, start building an MEF, speak with one voice, and ensure that we are always consulted on any changes to the law and any amendments to any act pertaining to employment. Thank you.
Thank you, Dato Jalal. I think that was very clear. So the message basically is that employers, we must come together under one roof, and in our view, there's no better roof than MEF. So I would strongly encourage employers to visit our website, and if you find us useful and relevant to your business, please do join us. And we have experienced consultants like Dato Jalal and many others who are always 24/7, not 24/7 lah, except for weekends, weekday hours, to attend to your queries and your issues. So thank you. I think we have reached our time limit, 11:30. So before I say goodbye, I would like to thank Haja Hastina and the membership team for organizing this session. And last but not least, to Dato Jalal, who has provided the substantive matters in the area of discrimination in the workplace. So thank you, and until next time, see you again.